Good evening, ladies and gentlemen. I'm Ritangshu Bhattacharya. Thank you, as always, for tuning in to the Urban Debate. Our big story today is the central question that affects almost every state which is ruled by opposition party member of the India bloc. Which office holds more power, that of the democratically elected chief minister, the head of the government of the state, or the centrally appointed constitutional head of the state, or the governor? Well, today the Supreme Court finally decided to draw a Lakshman Rekha in the government versus governor battle, and it made an example out of what was happening in Tamil Nadu. The court has delivered a firm reminder on constitutional boundaries, ruling that Tamil Nadu Governor R.N. Ravi acted illegally and arbitrarily by holding assent to 10 bills which were passed by the State Assembly. The court made it clear, once the Assembly passes and then repasses the bill, the governor is constitutionally bound to give assent. He cannot then send it to the president after that and keep it in limbo. This ruling is a major boost for Chief Minister MK Stalin's government, which has repeatedly accused the governor of overstepping his role. The judges of the Supreme Court did not hold back. They said that the governor's actions lacked good faith and set strict timelines for such decisions going forward. Ladies and gentlemen, very quickly before I go across to my guests here, the debate has to be set up. This verdict isn't about Tamil Nadu. It reaffirms a delicate balance between states and the center and draws a hard line against political interference of Raj Bhavans. In short, governors must stick to their constitution, not their personal preferences. That's the Lakshman Rekha that has been set by the Supreme Court. Raj Bhavans cannot have their own Raj run unchecked. That at least is the message that's come out here. For more on that, I will go across to my guests who are waiting patiently. But first, let's go to the, one would say, the man of the hour, especially if you're from Tamil Nadu. Our newsmaker of the day is Mr. P. Wilson. He's a DMK MP and he's also the petitioner in this case in the Supreme Court. Mr. Wilson, thank you so much for joining us on Mirror Now this evening. You were the petitioner in this case. What finally pushed you to move the Supreme Court? Has the breakdown between the state secretariat and state government and the Raj Bhavan reached a point where the only option left was to knock on the doors of the apex court?
Mr. Ritangshu, so our Honorable Chief Minister, Mr. MK Stalin, gave a long rope to the governor. In fact, the bills were passed from 2021 onwards till 2023. We gave him a long rope. We waited. The Honorable Chief Minister waited, but the bills, were lying in his shelves, cupboards. So therefore, after waiting for such a long time, not only with regard to the bills, but even remission of sentences, where the prisoners are entitled for a remission of sentences, that file was not acted upon. Not only that, even the appointment of the chairman and members of the Tamil Nadu Public Service Commission. So therefore, and the another thing is under the Prevention of Corruption Act, the governor has not given his sanction. Even today, he has not given a sanction. The files are lying with him. So therefore, after exhausting all remedies, the Honorable Chief Minister felt that the only remedy is to go before the Constitutional Court. And that is why he has rightly asked us to go and file a writ petition, and that's how we landed in the Supreme Court.
So, Mr. Wilson, the court today, while came up with those very damning words, it said that the governor acted illegally and he acted wrongly, he did not act in good faith. What do you make of these very stinging observations from the Supreme Court which accompanied its order?
The Supreme Court, Honorable Supreme Court, I am first of all grateful and thankful to the Honorable Supreme Court for this landmark judgment, and it's a trendsetter for all the democratically elected governments and even the people. It ultimately said that the will of the people has to prevail. So I have to thank the Honorable Supreme Court and the judges who have written a wonderful judgment. So far as the observations of the Supreme Court against the governor, it is all borne by records. I will tell you how the Honorable Governor attempted to not only frustrate the government, When we went to the court, he attempted to frustrate even the court also. What happened is, when we moved the court, the bill was not moving. He has not even given any assent to that bills. So we filed a writ petition with a prayer that he should give assent to the bills. And not only to the bills, but he has to process the other files, which I just now told you. What he did is, when we moved the writ petition, he withheld the bill, and he did not send back the original bills, but he sent back the file alone. You have to note down what I'm saying, because it's very important. So when the matter came up before the court, he said that he has withheld the bills. Then what we did is, we immediately, our Honorable Chief Minister, in a special sitting, the bills was reenacted and sent back to the governor again. So when the bills are reenacted and sent back to the governor again, then the Article 200 clearly says that he has no choice at all. He has to give assent. So what he did is, this time, in order to overcome the proceedings, that time the Punjab governor's case also came. The Punjab governor's case, the Supreme Court clearly said that once the bill has been reenacted and the same bill is sent to the governor has no choice at all. So the governor has to give necessarily the assent. What he did is, to overcome the proceedings and overcome the Punjab governor's case, he forwarded that bill to the assent of the president. See this. He wanted to frustrate the proceedings at every level. And so we had to, necessarily amend our application. We had to amend the writ petition, and we asked for a prayer for a direction that those bills which has been sent by him has to be restored back to him. Meanwhile, what he did is, he wrote another letter to the President of India saying that those bills have to be rejected. Normally, a governor is expected to act under the aid and advice of the Council of Ministers at every level, be it you see or give the assent to the bill at the first instance, or even it has to be forwarded to the president. For that also, you require aid and advice of the Council of Ministers. But here in this case, what he has done is, he wanted to frustrate the proceedings. He wanted to frustrate the order passed by the Supreme Court in the Punjab governor's case. He directly communicated to the President of India to reject our bills. And the Honorable President, of course, this is also, you have to see, he has gone to the level of influencing the Council of Ministers of the Union Government, and the Union Government Council of Ministers has advised the President to withhold the assent. Now, why did we ask this prayer is, so much of time has been consumed in litigation, and already 2 years and 3 years where he has taken time to grant assent. Why he refused to grant assent is, he can't be a judge of his own cause. All these bills removes him from the post of a chancellor. So his thing over control over the university goes up. So a person who is interested of his own cause, he had been a judge. And he wanted to frustrate not only the court proceedings, but also the people's will, the legislative assembly, second time, reenacting and sending back the bill. That also he wanted to frustrate. So in a landmark judgment, Supreme Court has not only, set aside all illegal actions. The governor probably thought that when it reaches the hands of Honorable President of India, no court will interfere. But today, in the landmark decision, they have not only said that they deemed to have granted assent, but they have said that if any action is against the Constitution, namely withholding of the assent, even that is also justiciable. And Article 200 doesn't give him power to create roadblocks, and he doesn't have a veto power.
Okay, so you've used the words landmark judgment multiple times, Mr. Wilson. Then is this a turning point in defining the governor's role? Because Tamil Nadu is not the only state where we are seeing a face-off between the state government and the centrally appointed governor.
Exactly. This judgment will have a ramification, not only ramification, it is clearly act as a guideline, and it will act as a guardrail for governors, persons like our governor R.N. Ravi, who think that he is unto himself and sky high is his powers. And this judgment really puts all the governors to a place. And the court has clearly said that, look, you have to act in accordance with the constitution. The court has captured the constituent debates, especially it has quoted in extensive the Dr. Ambedkar's speech, and has clearly said that, look, you can't be a roadblock, and you can only be a friend, fire guide, philosopher, and what is expected from you is only you have to act under the aid and advice of the Council of Ministers. And I think this judgment will certainly put all the governors at a place, and hereafter they can't think that they have absolute powers, and they are governed under the constitution.
All right, Rumanandri, Mr. Wilson, thank you so much for joining us on Mirror Now. Mr. Wilson is, of course, the DMK MP who was a petitioner in this case. Let me now go across to my guests who have been waiting quite patiently while we were listening to Mr. Wilson. We have Yadini PM, spokesperson of the DMK. Madhavan Narayanan is a senior journalist. Kovai Satyanan is spokesperson of the AIDMK. I'm also joined by Manish Barriar, who's a political analyst. Thank you all for joining me. Let me flip the script a bit because this is seen as a predominantly BJP versus DMK face-off. So let me start with the spokesperson of the AIDMK. Mr. Kovai Satyanan, we haven't really heard from your party much in this entire run-up to this entire battle between the governor and the chief government of your state. Would you not welcome today's verdict? Because I'm sure no party of Tamil Nadu, whether it be, whichever party is ruling at this point, whichever Dravidian party, no party would want the state's autonomy to be corroded or eroded by a central authority.
Good evening. I thank you for the opportunity, but please refrain from painting a picture. You please understand the ideology of Dravidian Party, our founder leader Anna. The word of a goat and a governor to the state is of no use and it's immaterial, and we stand by the ideology. And we welcome this move. What is more important is taking the governor into accountability. That's what more important it is. All we see is we welcome the move, we welcome this judgment by the Supreme Court. At the same time, this shall be short-lived is what we anticipate. I'll tell you the reason why. TRS, Telangana Rashtriya Samiti, I'm not wrong. Last year, they went to the court seeking the court's intervention and direction to set a timeline for governor to act on any resolution or bill that has been passed by the state assembly. So far, what governors of every state are doing is they are taking the shelter of timeline. They are not time-bound to act on any resolutions or bills that is being passed. That is an excuse every governor, irrespective of whoever is in the center, be it Congress or BJP, take an excuse. What is more important is today, the Supreme Court has reiterated the Constitution. What is being said in the Constitution, how a governor role has to be. Supreme Court has reiterated what Constitution is telling. But what is more important, the real victory, the real celebration shall be there when the governors are being made accountable based on the timeline. That is what we look forward to. And the state autonomy is hampered every time. Why? Because every governor tries to run a parallel government. And in this case of Tamil Nadu, Alner Ravi went one step ahead, trying to be a quasi-judicial. He says a law which is being passed by the state government should not contradict the one which is being passed by the center. He cannot play that role. If that were to be the case, all he has to do is he has to give his consent to it. That will be challenged by the center in the judiciary. And many an occasion, governor took the role of the judiciary by himself, stating that let me take a clarity on the law, what law says. So I would say reiteration of the Constitution is what Supreme Court has done today. This will be short-lived. This joy will be short-lived because until unless you make the governor accountable with a timeline, with X number of days that he has to act, say yes or no for a bill passed, that's the day where we can share about that will be the real victory for a state autonomy.
Okay. Yadini PM, please comment on this view, which your AIDMK colleague has said, that this is at best a Pyrrhic victory and is something which will be short-lived.
I'm just surprised if Mr. Kovai Satyan has read the judgment, because the Supreme Court has upheld has actually imposed a strict timeline frames on the governor in this. It's the first time in the last 75 years of the Indian independence that the Supreme Court has imposed very strict timeline frames, right? The Supreme Court has said that the governor should send the bills to the president upon the advice of the cabinet minister's advice within 1 month, and if he's going to send it to the president against the advice of the cabinet, he should do it within 3 months, and he should return the bill with the explanation to the assembly within 3 months, and he has to give an assent once the bill has been passed for the second time and sent to the governor within 1 month. These are the strict time frames that the Supreme Court has imposed. I think it's the ADMK. The ADMK had actually questioned DMK when the DMK had passed certain bills, all these bills for the second time in the state legislative assembly. They questioned the necessity why the DMK is passing it for the second time, and the answer, I think we have the answer right now, because DMK knows what constitution the constitution is about. I think this particular judgment, it actually ends the BJP's strategy of using the indefinite silence as a veto power through the governor. And the most important takeaway from this particular judgment is that since the BJP has come to power in 2014, the governors have been being operating under a dangerous illusion that they are beyond the judicial scrutiny. But this particular historical judgment, it actually shatters that particular myth, and the governor's actions, and moreover the inactions of the government upon the direction of their head offices in both Delhi and the Nagpur, they are subject to judicial review, is what the Supreme Court has upheld in this. So the governors can no longer act as an unaccountable monarch. I think this should satisfy Kovai Satyan's worries. And the most important,
we'll get back to Mr. Kovai Satyan. Yeah.
No, I'll just finish it off. Yeah. Because I see five important takeaways. Yeah. I've spoken about three. The fourth one being this particular verdict. It can't just be seen as a particular legal victory, but it is more about a political restoration of the state rights by the DMK, is what is how we are supposed to see it. Right. The Supreme Court has upheld that if it's passed for the second time in the assembly, that the governor should give assent to it, and he has no absolute veto power. He cannot deny his assent. So this actually gives more power to the elected state governments. And just as you said, it's not just about Tamil Nadu, it is also about the other opposition's ruled states, most likely like the Kerala.
Yes, and we'll talk about all of that. Let's take this issue by issue.
Yeah, sure.
Let's take this issue by issue, ma'am, which is why I just wanted to, let's take it. I mean, let me bring in Manish Barriar, and also let me bring in Madhavan into this discussion as well. Manish, it's not a coincidence that since 2014, suddenly we have seen problems between a governor and a state government ruled by any member, any ally of the India bloc right now. It's not suddenly a coincidence that by 2014, suddenly all governors in coincidentally just opposition ruled states decided to suddenly go on a war pot with these governments. It's kind of obvious that they were being done at the encouragement and at the at the behest of the central government, which is run by the BJP. Is this not a damning indictment by the Supreme Court? The fact that the governor was acting in bad faith, it could not get more open than that. Is the central government and are all these governors, and by extension the central government, guilty of trying to subvert the constitutional spirit?
Good evening to you and my co-panelists and all the viewers. So every word uttered by Supreme Court cannot be a gospel, isn't it? And I think they themselves have to really put their house in order, as we have seen. But anyway, let's come back to this judgment. So it's a classic case of judicial overreach in executive domain, because Article 200 is very clear, right? Okay. It's very subjective. It talks about reasonable time. By putting this timeline of 1 month and then 3 months, I think Supreme Court has gone into very dangerous territory. So tomorrow, it might say that, okay, President cannot withhold any bill of central government's any bill which is there. And President has to put a 1 month timeline. Tomorrow it can reach to Speaker on anything. The Supreme Court then can say that, okay, the files are being moved by bureaucracy. I want it to be done in 10 days. Right. So I feel that this is bizarre. It's a governor's position is a very good example of checks and balances. There have been times in Punjab where the state government has taken decisions which were contrary to national interest. right? And there, it has happened in some other states also. And at that time, government has played a very important role to ensuring that those things are not passed by the assembly. So I feel that I would take it with a bit of pinch of salt, this entire thing, because from outside it looks, wow, everything is being done in a fast manner, and the governor is being looked at in a certain way. I will come back to your question also, whether it's 2014. I think you have to take the memory back to before that, to 40 years also. The maximum number of times the governors have been used to use Article 356 has been by the Congress government, right? But show me in last 10 years where
Mr.
this
Barriar,
government...
how long will we continue to justify what's happening now based on what happened in
No,
1975?
but then you mentioned it about it,
Why?
Ritangshu.
Why should I go back 40 years ago? My
You cannot
government is
ascribe, in
accountable to
fact,
me now.
murder of democracy has happened during Congress party. And look at this is nothing that has happened. And ma'am from DMK, she mentioned that some of the powers of governors have been, like university case, right? Now, these are domains of actually governor. Historically, it has been like that. The educational institutions, the chancellor has been governor. So obviously, when these kind of things comes, it's a matter of public interest. And it is in the realm of governor to really take reasonable time and to put up this bill in a particular manner. So I feel that
What is a reasonable time?
this is a very, very dangerous kind of a judgment that has happened, and it is open to misuse. Because
Okay, so you're saying it's a dangerous judgment, judicial overreach. These are very loaded words, very similar to the words used. I mean, as loaded as the words used by the Supreme Court itself. I will let Yadini. I think you want to make a point. After that, I'll go to Madhavan, who's been waiting quite patiently. Yes, Yadini, you wanted to ask a question.
What's surprising is that Mr. Manish is calling this as a judicial overreach, but he couldn't understand or see how the governors have been misusing or abusing their power. Wasn't that an overreach of their powers? And he says that the universities have always been under the governors. Our question is, it was the BJP through the UGC guidelines amendment that gave the governors the power to appoint the vice chancellors, whereas it was with the states. The right was initially with the states, but unconstitutionally, by means of just amendment of just passing a circular, that the Union BJP government easily transferred the power from the states. And with this particular judgment, he talked about the president's power being curtailed by the Supreme Court, right? With this particular judgment, that 7 bills that were rejected by the president have also become nullified. And he talks about the reasonable time in the constitution, right? The constitution says as soon as possible. When you say as a host, you say finish this point as soon as possible. I and the other panelists, we have an understanding that we are supposed to do it with a sense of urgency. But the governors have been sitting on the bills for quite a long time. I want to know what is a reasonable time. So it is the governors and the Union BJP government who have been using this term as soon as possible as a loophole, to delay the passage of the bills in the state government.
Okay, Madhavan Narayanan, I personally feel that there should never be a scope for any loophole or any ambiguity in matters regarding governance. But when there is one, as our panelists are pointing out, whose authority should be supreme? Because Mr. Barriar would say that if there's something against national interest, the central government or constitutional authorities appointed by the central government should have the power to intervene, like Mr. R.N. Ravi has accordingly when he had issues with the state anthem, state song taking precedence on the national anthem and so and so. But should that necessarily be given as a pretext to impose the will at the end of the day over a democratically elected government by a state? Then why do we have federalism in this country?
Talking to me as Ritangshu, I didn't get your initial thing. So let me begin by saying
that question was to you, Madhavan.
The preamble of the Indian Constitution begins with the 3 words, "We the people of India." So it begins, it's a bottom-up republic. It's not a top-down state. But what happened was, I have to give you some historical and conceptual background to really get you a hang of why what has been attempted by Mr. R.N. Ravi in Tamil Nadu is a constitutional coup, nothing less. He's been acting less like a governor and more like a viceroy of an imperial power. And this is not just because of some files, his entire conduct, and let me stretch the background to Kerala and Bengal also, West Bengal, where Governor C.V. Ananda Bose and in Kerala, Arif Mohammad Khan, who's since been transferred to Bihar, have all been acting in a way where there is a clear pattern. And it's not a one-off incident of 2 or 3 bills being held up. There has been a constant attempt to convert a game of cricket into one of kabaddi. Call it a reversion to the mean or a cultural decline, but this is a fact that we need to take note of. Second, I mentioned we, the people, at the beginning. So in the case of any doubt, an elected government has a power, except in cases where there is a threat to, there is a breakdown of constitutional machinery, which is not to be confused with the breakdown of even law and order in the strictest sense of the term. And also, things like where there's a hung assembly or where there is an impossibility to form the government. So the governor historically exists essentially as a figurehead for most parts and is bound by the council of the ministers, has a certain responsibility to trigger a public debate by withholding assent and sending it back, but not indefinite, because the ultimate residual power is with the elected government, which is what the Supreme Court is interpreting today. But what I'm concerned now, especially after what Mr. Barriar said, if you're going to criticize the Supreme Court, then we should criticize it on everything from electoral bonds, where 8,000 crores are still with the ruling party, although the Supreme Court struck down the bonds as illegal. Do we call it a scam or not? We can criticize the judiciary, but we have to respect the judiciary. And let me be very clear and blunt and very honest. If the Supreme Court is not respected, the game of democracy is over. So we have to take the authority and ensure the independence of the judiciary. And if we start questioning the judiciary, then we'll question everything. It's anarchy, nothing else. Okay, let me be very clear there.
The point is,
hello.
Madhavan, yeah, please go on, complete your point, yeah.
Yeah, I think the key point to note is that when we adopted the British parliamentary system, we wanted to reserve some of the sanctity of the offices. So we don't have the Queen, so we put the president there with some dignity. Similarly, governors were ensured in such a way because it's a post-colonial government trying to modernize and decolonize at the same time. So the governor's office was given some residual powers. So gross abuse has taken place under Congress when Article 356 was misused. Let me give you an example. Karunanidhi was dismissed for his alleged links with LTTE, and today there is a political party in Tamil Nadu called Nam Tamilar Katchi, which swears by Prabhakaran of LTTE as its hero. So everything is very ad hoc and arbitrary. The governor's office has been abused, and today's judgment should be taken as a wake-up call to ensure safeguards, because this is becoming like the 42nd Amendment during the emergency, where there was a lot of abuse of powers by the central government. We don't want it, if you look at it, everything, it's a diverse.
I mean, I agree with you, Madhavan, on the ironies that exist here. I mean, the DMK government, which was dismissed by the same party with which it is a very close ally right now. Those ironies exist in Tamil Nadu. But the point which I wanted to make, I mean, counter to what you're saying, the Supreme Court should not, I mean, can be criticized but respected. Even the opposition is not shy of criticizing Supreme Court judgments and calling them vested. We are seeing what is happening with Mamata Banerjee in response to another very important contentious Supreme Court order on the teacher scam. Leaving that aside, Mr. Barriar, you pointed out, Manish, that there cannot be a time frame on reasonable restrictions, and a gun cannot be put on the governor's, on the president's head that it has to be resolved in 1 month, it has to be solved in 2 weeks. Now tell me something. Is 5 years a reasonable amount to sit on a bill? Let's have a list of those bills which have been stopped. There are 10 bills at this point. The earliest start from 2020. It is 2025. 5 years is the tenure of an elected state government here. Is it acceptable for any constitutional authority, under whatever pretext, to sit on a bill for 5 years after it has been passed twice by a democratically elected assembly?
I think, Ritangshu here, context is important. Of course, I don't agree with, some of the cases where what you talked about, 5 years. I'm not in favor of that. But you cannot paint every bill that has come with the same brush, right? You have to also look at the context, the way the governor in Tamil Nadu has been heckled, his constitutional position has been compromised, he has not been given respect. And you also have, why only governor? The prime minister comes in and the chief minister is not there. He doesn't really follow the protocols. So to expect that the governor is going to follow the same is actually asking too much, right? They have been quite brazen with the constitutional, positions.
Mr. Barriar, what childishness is this? The governor is sworn by oath to follow his constitutional duty. If he has not been treated well by the state government, one can understand his sentiments, but why should he then abdicate his duties because he's not been given due respect by a government?
Ritangshu, it's not about treatment. I think it's about sanctity and dignity of that constitutional position, right? And it is not hidden from anywhere that the way that constitutional position has been violated number of times. So, and then to expect that, yes, everything will follow and that reasonable time would also come. I think that is also, it's a personal tussle which has gone. And that's a very personal case which has happened here. But there are so many states in the country, we don't find that kind of a tussle happening. I think there is some responsibility of the Chief Minister and state government also. But having said that, I would also like to say that, then this will open a Pandora's box. The state governments can come up with populist bills, they can come with really financially irresponsible schemes, policies, and you mean to say the government would actually be a mute spectator. I would also contest the governor of a state is a quasi-federal structure, and the governor has certain
No,
powers.
But there's a problem with that statement There's a problem with that statement you're making, Mr. Barriar. Let me bring in... No, there's a problem with the statement you're breaking. You're saying, and let me bring in Madhavan as well to respond to this. Madhavan, Mr. Barriar is saying that if a state government comes up with a financially or irresponsible bill, it's the central government's job to ensure that this irresponsible bill is not passed. Then aren't we necessarily equating that the central government is always responsible, always works in national duty?
No.
Okay, Mr. Barriar, you're saying I'm misquoting you. Please clear your point. What are you saying then?
Yeah, I was not saying that.
Let me not be accused of misquoting, Mr. Barriar. Go ahead, Manish.
Not the central government. I was talking about governor. That governor has the responsibility to ensure.
Okay, fine. The governor. So we are saying that, okay, that makes it actually even worse. That makes it worse. We are saying that 234 elected lawmakers of a state government who are actually accountable to the people every 5 years, their collective wisdom is less than that of someone who's appointed by the President's house, by Rashtrapati Bhavan, has no accountability to the people. Madhavan Narayanan, what do you say about that?
Yeah, very simple. The Constitution defines the powers very clearly. So the governor's role is not a supervisory role. It is essentially what you call a presiding figurehead, a certain, ornamental role, with some exceptions where, as you rightly said, you can place the issues before the public by withholding assent and sending it back to the assembly so that it's debated in the wider domain and there is a room for course correction. But it is largely an advisory role. And as far as respect is earned, but Constitution is obeyed. So that's where the today's essence of the Supreme Court judgment is. You can go home and bitch about us, but you have to obey. So this is the essence of that. And the most important part, Ritangshu, I'm glad that you pointed it out.
Okay.
We are a republic first. We are not some ancient kingdom. So some of the cultural habits and the baggage of the criticism of the Supreme Court comes from the Freudian slips of being rooted in a culture of kings, not a culture of the republic. That is where I think all the young viewers watching this program should remember, we are a republic first, not a kingdom.
Okay, Yardini PM, I just want to make a point. I just want you to comment on the statement which Mr. Barriar said. Respect at the end of the day. I mean, at the end of the day, the governor and the government of the day should have a cordial relationship and should not be at loggerheads. That's what every responsible citizen says. Is this Tamil Nadu government absolutely, can the government absolve itself of not doing its part to ensure cordial relations with centre? Because we saw what happened this Sunday. The Prime Minister came for the inauguration of a very important bridge and the Chief Minister of the state was not even there to receive him. Laws might not be broken, but surely protocol dictates that Mr. Stalin should have been there.
No. The DMK has breached any protocol or has not, respected the sanctity and dignity. I would just like to make a rebuttal there. He said that the DMK has broken the sanctity and dignity. Let me put it to the audience. Wasn't it the governor who, breached the sanctity when he called on to the vice chancellors and asked them to implement the national education policy? Does he have the authority to do that? Is he a political personality? to do that. He's merely a constitutional head, right? The second one, he said that a bill is dead if he withholds an assent to it, right? And even Justice Chandrachud had, in the case of the Punjab governor, he said that this is not right. This is constitutionally, it is incorrect one. So it was the governor who breached the sanctity of his office. Third one, with regards to the need bill, he said he will never give assent to a need bill which is passed by the state legislature. Who is he to decide what is good and for the the residents of Tamil Nadu? It is the state government that has the mandate of the people. It is the state government that knows what's the will of the people. Who is he to decide to not give? Does he even have the authority to say that he won't give an assent? Third one, with regards to the reinducting Minister Ponmani back into the cabinet, he said he wouldn't do it when he did not have the authority. So who breached it again? When he was so concerned about the corruption case against Ponmani,
I think I need to end this debate. We have had some very important points being discussed.
Absolved of. He went on to go and show his solidarity to a vice chancellor who has been proven of his corruption by a high committee. So who has breached the sanctity of his office? It is the governor himself who has breached the sanctity.
Okay, we have point taken. Point taken, Manish. Mr. Barriar, I don't want to give you the discourtesy of not giving a point. So if you can wrap up it in 20 seconds because I'm seriously over time.
Yeah, I just wanted to put something like this, that, the Supreme Court itself, in earlier rulings, they've recognized that governors are not bound by fixed timelines. Now it is actually contradicting its own jurisprudence. That's the only thing I wanted to say. It's a food for thought.
Okay. See, I will say that, even an elected government should have checks and balances and should not be just 5 years. Because as you said, otherwise we'll have a slew of populist bills which will cause to financial ruin of a state. That we're seeing that. But the checks and balance is the judiciary. It's not the governor. I'm not a constitutional expert, but even class 8 civics tells me what a governor's role is supposed to be. We have seen the law being we have seen the law being laid down once again by the Supreme Court. It remains to be seen whether this is upheld, because we have seen too many governor versus government face-offs. And unfortunately, I don't think this will change. Even if the government at the center changes, we will continue to see these things, possibly these loopholes being exploited. But thank you so much, Yadini, Madhavan Narayanan, and also Manish Barriar for joining me with your views. It's time for a short break. The Urban Debate continues with Sneha Koshi. Stay tuned.